Good morning, students. So, in the previous session, we discussed about the case of Shanti and Mr. and Mrs. Shinde, in which we concluded that there are four key players in the criminal justice system: the police, the public prosecutor, the defense lawyer, and the judge. Today, we'll be elaborating their duties and their roles in the criminal justice system one by one. So, the very firstly, we'll be discussing about the role of police in investigating a crime. One important function of the police children is to investigate any complaint about the commission of a crime. जब भी पुलिस के पास कोई complaint आती है regarding a crime, so their very first and the most important function is to investigate about it कि the complaint which has been made to them is actually true or not. An investigation will include recording of statement of the witnesses and collecting different kinds of evidences. On the basis of the investigation, the police is required to form an opinion. Now, after checking everything, after investigating everything, the police, they have to form an opinion. That means that they have to think whether the complaint that has been made is real or not. Now, on the basis of that, if the police think that the evidence points to the guilt, कि जिसके अगेंस्ट ये कंप्लेन की गई है, if the evidences point towards them, if they prove that yes, the complaint is true, then they will file a charge sheet in the court. As stated at the beginning of the chapter, it is not the job of the police to decide whether a person is guilty or innocent. That is for the judge to decide. पुलिस को सिर्फ इन्वेस्टिगेट करना है, और अगर जो एविडेंसेस हैं that proves कि कंप्लेन जो है वो ट्रू है, तो they have to take the things to the court. Now you read about rule of law. That means that everyone is subject to the law of land, that every law is applicable to everyone. So this includes the police also. So therefore, police investigation is always conducted in accordance to the law and with full respect of human rights. Investigation के लिए आप किसी के भी fundamental rights को वायलेट नहीं कर सकते या किसी को भी पर्सनली हार्म नहीं कर सकते. द सुप्रीम कोर्ट, दे हैव लेड डाउन वेरियस गाइडलाइंस दैट आर टू बी फॉलोड by the police at the time of arrest, detention and interrogation. Arrest, you all know. Detention, when you are detaining, you are keeping someone in the police custody, and interrogation means the question answer session. So there are a few rights which have been given to the citizens of the country by the Supreme Court, and police is not allowed to torture, beat or shoot anyone during the investigation, because police cannot decide कि उस person ने crime किया है या नहीं. They cannot inflict any form of punishment on the person, even for any of the crime, even for any of the offense. It is completely the decision of the judge. Now, Article 22 of the Constitution and criminal law guarantee to every arrested person the following fundamental rights. Now, the Article 22 of the Indian Constitution has given several rights, fundamental rights to the arrested person. Let's see what are those. The rights are the right to be informed at the time of arrest of the offense for which the person is being arrested. Secondly, the arrested person has a right to be presented before a magistrate within 24 hours of the arrest. The time he has been arrested, तब से लेके 24 hours के अंदर he should be presented in front of the magistrate. Then, right not to be ill-treated or tortured during the arrest or in custody. The police officer cannot torture any person during the arrest time until and unless he is proven guilty. Then, confessions made in the police custody cannot be used as a evidence against the accused. Whatever he has said in the front of the police during the when he is there in the police custody, that particular statement cannot be used as an evidence, because that confession may be due to the fear. Then a boy under 15 years of age or woman cannot be called to the police station only for questioning. You cannot call any woman or a boy who is below 15 years of age for questioning in the police. Then children, the Supreme Court of India, they have laid down specific requirements and procedures that the police and other agencies have to follow for the arrest, detention and interrogation. These guidelines are known as DK Basu guidelines, and a few of them are here in your book. Let's see what are they. They say that the police official who carry out the arrest, who is arresting any person, he should wear clear, accurate and visible identification and name tags with their designation. That means they should be proper, they should be in a proper police uniform. Then a memo of arrest. Memo means it is a kind of, you can say, a written document which says that the arrest has been done. So a memo of arrest should be prepared, and it should include the time and date of the arrest, and it should be attested by one of the witness in front of whom you are arresting the person. उस time उसके साथ जो भी present, a family member, a friend or whosoever, that document, that memo of arrest should be signed by that witness, and after that it should be countersigned by the person himself. Then the person arrested, detained or being interrogative has the right to inform a relative, friend or a well wisher. जिसको आपने arrest करा है उसके पास ये right है कि अगर वो चाहे तो he can inform one of his family, मतलब वो एक कॉल करके किसी को भी inform कर सकता है जिसको भी वो inform करना चाहता है. Then when a friend or a relative lives out the district, the time, place of arrest and venue of custody must be notified by the police within 8 to 12 hours of the arrest. So these were about a few things which a police need to follow while arresting a person. The next topic that comes is children, FIR, or if I say the first information report. Now what is an FIR? So children, it is with the registration of an FIR that the police can begin their investigation into a crime, because it is the very first information that is given to the police regarding the occurrence of any crime. The law states that it is compulsory for an officer in charge of a police station to register an FIR whenever a person gives information about a cognizable offense. This information can be given to the police either orally or in writing. The FIR usually contains the date, time and place where the offense have taken place, along with the details of some basic facts including the description ki kya kya हुआ है, and if known, the identity of the accused persons and the witnesses is also mentioned. अगर पता है कि ये crime किसने किया है तो उसके बारे में भी उसमें information होती है. It also states the name and addresses of the complainant. जो complain करने आया उसका name और address भी होगा इसमें. There is a prescribed form in which police registers an FIR and is signed by the complainant. पुलिस के पास एक complete form type पेपर होता है जिसके ऊपर वो सारी इंफॉर्मेशन फिल करेंगे और उससे साइन करवाएंगे बाय द वन हु हैज कम फॉर मेकिंग अ कंप्लेन, एंड द कंप्लेनेंट आल्सो हैज अ लीगल राइट टू गेट अ फ्री कॉपी ऑफ FIR फ्रॉम द police. So this was about the role of police in the criminal justice system, the very first person. Secondly, who comes is the public prosecutor. So a criminal offense is regarded as a public wrong. जब भी कोई criminal offense होता है, whenever a crime occurs, तो वो एक particular singular person के against नहीं होता children. It is a crime against the entire society. Now what is meant by this? That it is considered to have been committed not only against the affected victim but against the society. Do you remember the case of dowry death जो हमने previous chapter में पढ़ा था in the example of appellate jurisdiction? Sudha was killed for the dowry. तो उस केस में आप लोगों ने पढ़ा होगा that case was presented against the accused Lakshman and his family. इस केस को प्रेजेंट किया था स्टेट ने. द गवर्नमेंट हैज प्रेजेंटेड दिस इन द कोर्ट क्योंकि सुधा हरसेल्फ वाज नॉट अलाइव टू फाइट हर केस. तो स्टेट की तरफ से ये केस कोर्ट में गया था, इसीलिए उसका नाम भी क्या था? स्टेट वर्सेस लक्ष्मण कुमार एंड अदर्स. तो सिमिलरली the above case में भी it was called state versus शांति हेम्ब्राम. क्योंकि ये जो क्रिमिनल केसेस होते हैं दे आर नॉट अगेंस्ट अ सिंगल पर्सन, ये किसी भी सिंगल पर्सन के साथ नहीं होते, इट इज क्राइम अगेंस्ट द एंटायर सोसाइटी। तो इसीलिए इन केसेस में हम पर्टिकुलर पर्सन को मेंशन ना करके हम किसे मेंशन करते हैं, स्टेट को एज अ whole. Now in court it is the public prosecutor who represents the interest of the state. The role of the public prosecutor begins when the police has conducted the investigation and they have filed the charge sheet in the कोर्ट। अब इसके आगे का काम पुलिस का नहीं है, इसके बाद जब कोर्ट में चार्जशीट फाइल हो गई तो नेक्स्ट द थिंग्स आर ट्रांसमिटेड टू द पब्लिक prosecutor. Now the prosecutor, he conduct the entire prosecution on the behalf of the state, he acts on the behalf of the state, and as an officer of the court it is his or her duty to act impartially. He or she cannot be partial on one of the side. Their duty is to present the full material, facts, witnesses and evidences before the court to enable the court to decide the case. क्योंकि द कोर्ट नीड टू नो, अब जज खुद तो हर केस की इंफॉर्मेशन कलेक्ट नहीं करेगा कि जो कोर्ट के अंदर फिगर्स और फैक्ट लॉयर्स प्रेजेंट कर रहे हैं आर दे ट्रूथ और नॉट। तो उस चीज को ओवरकम करने के लिए वी हैव अ पब्लिक प्रोसिक्यूटर हु एक्ट्स ऑन द बिहाफ ऑफ द स्टेट। ही कलेक्ट्स ऑल द इम्पार्शियल इंफॉर्मेशन अबाउट द केस एंड प्रेजेंट इट इन द कोर्ट टू मेक इट पॉसिबल फॉर द कोर्ट टू मेक impartial decisions. After public prosecutor, children, the next comes the role of the judge. Now judge is like an umpire in a game. You all know in the cricket game there is an umpire who makes the impartial decision for both the teams. So judge is also like an umpire who conducts the trial impartially in an open court. Open court means where everybody is present in the presence of the people. The judge hears all the witness and all the evidences presented by the prosecution and the defense. After looking through all of them, the judge decides whether the accused person is guilty or innocent on the basis of evidence and with accordance to law. And if accused is convicted, agar पता चल जाता है it is proven that the accused he has done a crime, then the judge pronounces the sentence. He then gives the punishment. He may send the person to the jail or impose a fine, or he can do the both depending on what the law prescribes कि इस crime की क्या punishment होनी चाहिए. Then children, the next question that comes out is what is a fair trial? Does anybody of you know? Okay. Let's just imagine children कि what would have happened if the judge decided to try Shanti's case very differently. What if the court did not give a copy of charge sheets? अगर कोर्ट ने charge sheets की कॉपी शांति को नहीं दी होती and the statements, what if he held the trial in a secret location जहाँ पर शांति और सुशील दोनों को ही ना बुलाया जाता? What if शांति की लॉयर एडवोकेट रॉय ने enough questions नहीं पूछे होते मिसेस शिंदे से और इंस्टेड उसने भी यही मान लिया होता कि ये शांति की गलती है, शी हैज़ डन द थेफ्ट. इफ दिस ऑल कंडीशंस वुड हैव कम ट्रू तो इट वुड बी अ केस ऑफ अनफेयर ट्रायल कि किसी ने शांति को अपनी चीज़ को प्रेजेंट करने का फेयर चांस ही नहीं दिया. This is because for a trial to be fair, several different procedures have been observed. Article 21 of the Indian Constitution guarantees right to life that states that person's life can be taken only away by following a reasonable and a legal procedure. आप किसी को punishment एक proper legal procedure के अंडर ही दे सकते हैं. A fair trial ensures that Article 21 of the Constitution is upheld and this law is never broken. Now let us now return to Shanti's case as described in the storyboard and identify the essential elements of a fair trial. Firstly, Shanti was given a copy of charge sheet and all the evidences. Then Shanti was charged with the offence of theft that was defined as a crime in the law. Secondly, the trial was in the open court in the public view, which made it a fair trial. Then thirdly, Her brother Sushil was also allowed to attend the meetings of the hearings of the court. The trial was held in the presence of the accused. Shanti के सामने हुआ. Then Shanti was defended by a lawyer. They could not afford it, but the court, on its own expenses, they provided them with the lawyer. Shanti's lawyer, Advocate Roy, was given an opportunity to cross-examine all the prosecution witnesses. And last, Advocate Roy was given the opportunity to present the witnesses in Shanti's defense. So all these things made this trial a fair trial. Although the police filed a case of theft against Shanti, but still the judge assumed her to be innocent. So it was the responsibility of the prosecution to prove beyond reasonable doubts that Shanti was guilty. In this case, the prosecution failed to do so. It is significant that the judge decided the matter only on the basis of the evidence before the court. पुलिस ने ये मान लिया था कि चोरी शांति ने ही करी है, but the judge, he was impartial. He did not listen to any of the one side. He conducted a fair trial and made a fair decision. The judge, he did not jump to the conclusion because she was a poor maid servant. Instead of that, he remained impartial. He went through all the evidences and finally she was given a fair trial. The constitution and the law both state that all the persons that we have discussed in the chapter should carry out their roles in a proper manner. What does this means? That all need to work to ensure that every citizen gets a fair trial, because the rule of law says that everybody is equal before the law and law will never make any person differentiate. It has given this right of fair trial to each and every citizen of the country. So it is the duty of all these four players of criminal justice system to work together to provide the equality to everybody given to them by the constitution.